All right, you guys have definitely studied the Bill of Rights. I know you know all the parts of the Bill of Rights and you can recite all of them, so you'll definitely recognize the right to privacy. Except that the right to privacy is not actually in the amendments anywhere. So it's time to take a look at the Ninth Amendment and talk about what the Ninth Amendment can do for individual rights. Okay, so the right to privacy. Um, this is going to be difficult. Like, we think of privacy usually meaning like keeping your things private from the government and all this kind of stuff. You guys may think of like, your searches of your online uh, communications and things like that. But those are all Fourth Amendment issues. When we're talking about what we call the right to privacy, in every instance that we're going to talk about today, we are pretty much dealing with sexual relationships. And so the right to privacy is going to put up a wall between the government and what happens in people's bedrooms. And so this is not spelled out anywhere in the Constitution. Obviously, writing the Bill of Rights or whatever, these old men in 1787 were not thinking about issues like birth control and things like that. But the Ninth Amendment reserves rights to the people. The Ninth Amendment says that there are some rights that are not specifically written but still protected from the government. And so parts of the different amendments would suggest that privacy is protected from government interference. If we think about the First Amendment, if we think about the Fourth Amendment, if we even just this one time only think about the Third Amendment, these are important rights that suggest that we have a reasonable expectation of privacy from the state. All right, so our first court case here, this is my favorite one. This is Griswold versus Connecticut. This is where the court creates a right to protect individuals from the government here. So in this case, this is back in the 1950s. The Connecticut law prevented any person from using any drug that would prevent contraception. And people were also prevented from giving out information about contraceptives. So this was a law that basically dealt with any form of contraception as obscene material. And so you could be punished for using any form of birth control. You could be punished for giving people any information about any form of birth control. Estelle Griswold in the picture there thought that this was crazy. And so she opened up a clinic and started distributing birth control to people. She did this on purpose. She wanted to challenge this law, thought that this law preventing people from accessing birth control was crazy. So she wants to challenge the law. She opens up her clinic. She gets arrested and she goes to the Supreme Court eventually. And the argument she makes is that the Ninth Amendment, includes other rights, and that the right to privacy ought to be one of those. The court ruled that if we take a look at First Amendment, you've got, remember, your freedom of expression, your freedom of association. Third Amendment, protection from the government coming into your place. Fourth Amendment, protection from unreasonable searches. Fifth Amendment, due process, protection from self-incrimination. And so if you combine those with the Ninth Amendment, the court decided that the framers intended for the right to privacy to be protected. This would be what the Ninth Amendment is for. Even though it's not written in the words of the Constitution, we know that they did not intend for the government to be regulating your private life. So Griswold is an important case because it establishes the right to privacy as a constitutional right. So this is just really interesting because the court creates a right based on an argument using the Ninth Amendment. This is a great use of the Ninth Amendment to show that people have more protection against the government here. So this sets up an important precedent for similar issues. So this was an issue dealing with birth control and saying that the government actually has no business regulating that aspect of your life. And so we'll have other cases that follow from here. So this is the important case that we must know by name. This is probably the most controversial and debated about Supreme Court decision that we have. We have Roe versus Wade. This is the case that deals with a woman's right to obtain an abortion. So this comes after Griswold versus Connecticut. There is a right to privacy. And in this case, a Texas law, many states had laws that banned abortions. Texas was one of those. And so Jane Roe is the lady on the left. This is a pseudonym. That's not her real name. She was unable to obtain an abortion in Texas. And so she sued, saying that because of the right to privacy and because of the 14th Amendment, that the state did not have the right to deny her that right to privacy. So the question that's before the court here is, does the right to privacy include a woman's decision to obtain an abortion? And so this case got before the court, and the court here is following the precedent of Griswold versus Connecticut. If a right to privacy exists, then states do not have the ability to take away that right. And so in this case, the court would rule that states could not ban abortions. So states are not allowed to ban abortions. The case also says that states can regulate them, but that they cannot be banned. And so this is a case that struck down bans on abortion in many states across the United States. So this is the important one that we have to know the name of, this Roe versus Wade. So ever since Roe versus Wade, the courts have become a battleground over abortions and over the state's ability to regulate those. So we have a couple of other cases here where we don't really need to know the name, but we do need to understand what's happening here. And so the first of these is Webster versus Reproductive Health Services. This is in Missouri. Roe versus Wade said that states could regulate abortion, and so Missouri passed a law that banned any government-employed doctors from performing an abortion and prevented any public money from any sort of counseling that would encourage it. And so this went to the Supreme Court. Is the state allowed to restrict abortions in this way? And the court ruled yes, that the state can regulate abortion. They create this standard called undue burden. So the court is allowed, the state is allowed to regulate abortions as long as the regulation does not just create some unnecessary burden for the women trying to obtain them. So that is kind of the standard for what regulation of abortion exists. And of course, it's not very clear. It is up to the interpretation of the judges, but this is the standard that we're dealing with. Another case that we deal with here is Planned Parenthood versus Casey. And so in this case, a Pennsylvania law said that they passed some restrictions that included a waiting period, and included parental consent. They had one law for spousal consent, and this got to court. And can the states restrict abortions in that way? So this was a case that dealt with, can we have a waiting period? Is that an unnecessary burden? Can we require parental consent? Is that unnecessary? Can we require spousal consent? What's important about this case and the Webster case is in both cases, the court said that Roe versus Wade is affirmed. They say that the right to abortion does exist, but the states can restrict. So in this case, the waiting period was okay. It is okay to require a waiting period. It is okay to require minors to to get parental consent. And the map on the left there shows how that's different state to state. The states that are either shade of blue or even either shade of blue there require parental consent, and the states that are kind of olive green, lime green, those states do not. So you'll see it looks a lot like an election map in a lot of ways. The spousal consent was ruled to be an unnecessary burden. So states cannot require spousal consent in order to obtain an abortion. All right, so a lot of the cases that deal with the right to privacy, those were all about birth control. We have a lot of cases about abortion because it's such a controversial issue, and because states are very some states are unhappy with the Roe versus Wade ruling and want to challenge it. Another place where the right to privacy has given important protections to individuals is the rights of same-sex couples. And so this will also deal with in civil rights, but this is another case that uses the right to privacy. So Lawrence versus Texas. This actually was not. This court case was 2003. So not until 2003 were these individuals protected from state action. But Texas had laws that banned certain sexual acts, and Lawrence on the left there was arrested for it. And so he would argue that the right to privacy should prevent states from being able to regulate his activities in this way. And so the states banning certain sexual conduct would be a violation of his right to privacy. And so that got before the court. And finally, in 2003, the court ruled that this is a violation of the due process clause and a violation of the right to privacy. So states do not have the right to ban certain sexual conduct. And so this is another important protection for individuals from state action. All right, so we've gone through the Second Amendment and the Ninth Amendment today. The time to take a look at our bigly ideas. There is President Trump celebrating his Second Amendment individual right to own a gun. All right, so we've really got two amendments to deal with today. We've got the Second Amendment and the Ninth Amendment. With the Second Amendment, it's going to be important that you can compare the theories there, because that shows us how courts' interpretation of amendments can change. So the interpretation of the Second Amendment changed in 2008, relatively recently. So this is an important development in how we treat the Constitution. And with the Second Amendment, we are going to have to know the case McDonald versus Chicago. So that was Chicago's handgun ban, and this case incorporated the Second Amendment protections. On the Ninth Amendment side, we're going to have to explain how the Constitution implies that there is a right to privacy. Remember, Ninth Amendment, rights reserved to the people. So just because it's not specifically written doesn't mean that it does not exist. So the Constitution implies with the First Amendment, Third Amendment, Fourth Amendment, Fifth Amendment that you have a right to privacy. And the case that we have to know for the right to privacy is Roe versus Wade. So couple of amendments, couple of court cases there. What we've seen is further protection of individual rights against government action. All right, so that's it for the Second Amendment and the Ninth Amendment. We are going to continue to talk about the balance between individual rights and protection against government action. And we're going to look next at the rights of the accused. So we'll be going through the Fourth Amendment, Fifth Amendment, Sixth Amendment, and Eighth Amendment.